So noted and overruled.
Mr. Chairman, my name is Jay Bone. I'm an attorney with the law firm of Schiller and Pittenger, PC. I'm standing in tonight for Mr. Drill on behalf of the Township of Greenwich. Contrary to what the applicant has been saying throughout the course of this hearing, the application does not comply with all applicable zoning, subdivision, and site plan ordinance regulations and requirements. First, the application does not comply with one of the critical conditions required for conditional use, specifically Ordinance Section 243-76. The ordinance provides that conditional use approval, quote, shall be granted only if the same will not be detrimental to the health, safety, and general welfare, close quote, and only if the applicant, quote, shall adhere to the procedures and standards established in the chapter, close quote. The facts are that the applicant did not prove, and the board therefore cannot find, that the proposed asphalt plant use on this site will not be detrimental to the health of the public in terms of groundwater contamination. Greenwich Township provided testimony from an environmental expert that the proposed asphalt manufacturing plant use on a particular site in issue, which is underlain by carbonate rock and a prime water recharge area, would have a negative impact on groundwater quality through contamination and consequently a negative impact on public health. Despite the significance of this issue, the applicant did not see fit to provide any expert testimony on the issue of contamination of groundwater, nor on the health impacts of that contamination. This is not an issue that the board can simply dismiss in the course of its deliberations. This is an issue that should cause the board to deny the application. Second, the application does not comply with Ordinance Sections 243-48D 6A and B, which contain the minimum geologic and engineering design standards related to the presence of limestone. The ordinance provides that the board must find that the applicant has provided, quote, sufficient design and construction information to ensure that the proposed development of the tract will not adversely impact on the health, safety, and welfare of the community, close quote. The ordinance further provides that the board must find that the applicant has provided, quote, specific details ensuring that the design concepts and construction and operation procedures to protect water will be properly implemented, close quote. Without construction details on the final site plans at the time of final site plan review and prior to approval, the board cannot find that the proposed development can be constructed on this specific site without adversely impacting on the health, safety, and welfare of the community. The board should thus deny the application. If the board were to delegate to the Township Engineer's Office the review and approval authority over the details, as suggested by the Township Engineer's Office, the board would be engaging in an unlawful delegation of its authority. The argument put forth by the Township Engineer's Office that this is how it has been done for the past 10 years is not a justification for not following the ordinance requirements. The argument is just proof that the ordinance has not been followed correctly. We urge this board to correct this long-standing mistake and follow the ordinance in this case. Under Ordinance Sections 243-48D 6A and B, site plan approval cannot be granted unless and until the details for construction of the building and structures in limestone geology are included on the final site plans, which are reviewed and approved by the board, not reviewed after the fact by the Township Engineer's Office. For this reason, the board should deny the application. Third, a planning variance is required to provide a private, not public road on which the two building lots will front. This is the only variance that the applicant has acknowledged exists in the application and the only variance for which the applicant has applied. Ironically, however, the applicant's own planning expert conceded that the applicant cannot prove the standards required for the planning variance under NJSA 40:55D-36. In fact, the planner admitted that the applicant can provide a public road without practical difficulty and without unnecessary hardship. The planning expert was quite candid that the reason that the applicant was proposing a private street was to save the township money by the township not having to maintain the new street. In fact, the board's engineering expert testified that he advised the applicant that he would not recommend that the township accept the public road if proposed. As the board knows full well, if the applicant had offered to give the township $10,000 in exchange for the variance, that would be reversed by the courts as illegal. The Township of Greenwich submitted that the proposing a variance to create a private street in exchange for the township not having to spend $10,000 on maintenance of the road is equally illegal. The request for the variance should be denied. Fourth, there is no question but that the proposed private street will be a third lot, since the street will not be an easement over the two building lots, and the street will have its own lot number. This creates additional variances, however, for which the applicant has not applied. Specifically, the minimum lot area for the ROM zone is 5 acres, and the private street lot is well less than that width. The board should deny the application for failure of the applicant to comply with these zoning ordinance regulations and for failure to have sought variances to permit those deviations. In conclusion, contrary to what the applicant has been saying throughout the course of the hearing, the application does